Get us kicked off here. So I wanted to welcome everybody to the Metrics and Analytics session. We have a special guest, one of our sponsors, Wolters Kluwer, is going to be presenting Nathan Semenska, and apologies if I'm butchering your last name, Nate. So we're very happy to have him here and to discuss about staffing matters. And we just wanted to remind everybody if they can put themselves on mute during the session, and please feel free to use the chat, to try to interject. Kelly and I will do our best to try to field those and get answers to you when we can. So Nathan, you're good to share your screen. Excellent.
And Nate, you're on mute, sir.
Oh.
It's possible he might need help coming off. There he is.
There he is.
Yeah, I'm good. Okay. Let's see here. Can everybody see my screen okay?
Yeah. Looks
Yes,
good.
sir.
Oh, okay. Thank you, everybody. Thank you for the warm welcome, Tara and Kelly. My name is Nathan Semenska. I work for Wolters Kluwer. We're one of the largest e-billing companies. I gave a presentation, I don't know, 3 or 4 months ago to this group. So I assume that a number of you were on that call as well. That call was about what we call mega matters, meaning matters over $1 million in the role that they play in outside counsel fees in corporate law departments. And today we're going to talk about a different issue, but it's coming out of the same source of data, which is LegalVIEW Data Warehouse. It's our data warehouse where we amass client data with their permission, and then we use that for research and product development purposes. And I'll start out with a personal story. I can say that for me, I've learned tons. I've absorbed tons from being in the world and working with different people and through education and all sorts of things. But actually, the most valuable experiences that I've had professionally are observing what not to do, right? And then just doing the opposite of that. I have seen what not to do with staffing ratios. And it was my introduction to legal operations. I had been working as an attorney for many years, and I got my MBA at night, and I switched into legal operations, and I was working for Elevate Services as a consultant. We had a client, and they had only had legal operations for a couple of years. They realized that they needed to save money, and they had done some stuff with smaller legal matters, single plaintiff labor and employment matters, immigration matters and things. But the thing that was 10 or 20% of their spend. So they were really sort of nibbling around the edges, and they kept having budget problems. And they realized that if they actually wanted to save any real money, they had to go after the big, ugly, hairy legal matters and try to save money on those. And there was a particular matter that they'd spent, I think, $60 million on approximately over a number of years, that was set up when they didn't have legal ops. And the head of litigation at that time got sticker shock when he saw a partner asking for $1,200 or $1,300 an hour, and he thought he was smart, so he negotiated a blended rate of $660 per hour for any timekeeper billing into that legal matter. That was like 5 years before I came onto the project. And I ended up working with a team of people, including another outside consultant. And we're looking at this legal matter, and he's like, you got to look at the staffing ratios because the blended rate. And we looked at them, And what we found was in contravention of our billing guidelines, all sorts of summer associates working on this, first years, project managers being billed out at $660 an hour, all kinds of stuff. And we, but the tricky part was we couldn't be sure that this was bad. It seemed bad. It seemed like the firm had people that weren't busy and they were just using our legal matter as a dumping ground. It had no budget on it or AFA or anything. And they were just throwing warm bodies at this for $660 an hour. Because if you can get paid $660 an hour for a 22-year-old summer associate, why would you not do that as a law firm? And I won't tell you how the story ended. It ended with a really ugly conversation, and the partner who flew all the way up to talk with us, the last thing he said when he left the room, walking out the door, I remember he was like, this didn't feel right, or something, the conversation that we had. So I think that is the danger that you risk if you're not paying attention to staffing ratios. But the tricky part is, as this presentation will probably reveal, it may not be clear what a good staffing ratio is in many situations. So what I've called this presentation is, how are your legal matters staffed? How should they be staffed? And are you sure? Because I think, unfortunately, perhaps this presentation is just going to raise a bunch of questions and not necessarily answer them. But I hope that you still find it to be valuable. Just a little bit of background. I won't go into it too much, but where is this research coming from? It's coming from our data warehouse that I mentioned. It's the largest benchmarking database in the world for legal costs. It's got over $150 billion of spend and associated data. And we've been using this to produce the real rate report, which remains the leading source of rate benchmarking data. We've been doing that for over 10 years, and we do a number of other things with that data, including powering our AI-assisted invoice review service. And we're getting more and more data contributors. We increased our data contributors by about 20% last year. So it becomes more and more powerful, and it powers various products. I mentioned our invoice review service, LegalView Bill Analyzer. We also have a product that predicts the likely spend and cycle times and staffing ratios of high volume, lower risk litigation, like insurance litigation. And then the real rate report that I mentioned, and some other rate benchmarking products that are baked into our e-billing systems. LegalView Insights is not just the findings that I'm about to share with you, but it's actually a series of thought leadership that's been going for over a year now. It's blogs, reports, white papers, webinars, and the report that I'm giving you a sneak peek of today will be released in the next couple of weeks, and it's free. So I hope that you all download it or get a hold of it in some other way. And the distinguishing characteristics, I would say, of this series of thought leadership are two things. The first thing is that we're trying to be better than survey data. I think that survey data is great. My company has worked with ACC, legal operations, and other people on all sorts of surveys, and I think they're great, but it's hard to keep the respondents consistent year over year. And the further you go out, the harder it is to keep that. And so if you start to see year over year differences, if they're too extreme, you wonder, is that a real change in the market, or is that a change in the sample? So we do not have that problem with the research that we'll be showing you today, because in our data warehouse, I'm able to keep the sample size to the exact same group of clients that we consistently use. The other thing that we're aiming for here is to try to go where no man or woman has gone before. There's all sorts of great sources of thought leadership in legal operations, and we're not in the business of duplicating quality work that's been done by other people. We're trying to look at underappreciated areas that don't get enough attention, with the hopes that that will be more valuable for audiences than just kind of confirming research that we already know from other sources. So this is a quote from Jay who was the director of Baker McKenzie of pricing for a number of years. She was a high-profile pricing consultant before that, and she now went back out on her own, I think, and is doing that. And she has this quote that appeared in a recent blog of hers on legal evolution. Bill Henderson from Indiana University's blog, which, by the way, you should check out. It, in my opinion, is the best source of information about legal operations that there is. But she makes this point that some of the biggest purchasers of legal services deploy buying tactics that further uncouple rate setting exercises from the meaningful examination of what work is needed by the corporation. So I've seen this. I've seen pretty mature corporate law departments with pretty built out legal operations function, but part of maturity seems to be increasing specialization and different people on different teams that are doing things that other people in legal operations, might not know what they're doing exactly. And I've seen this with procurement, hammering on rates, but not necessarily worrying about, the big picture, not taking a holistic approach and just wanting to get those rates down. And the point that Jay is making here is that better rates don't necessarily lead to cheaper outside counsel fees. And she uses this hypothetical situation, firm A versus firm B. And firm A is a composite of AmLaw 50 firms, basically. Firm B is a composite of AmLaw 151 through 200 firms. And, if you just look at this without thinking about it too much, you say, oh, wow, partner rate, $1,200. That's almost 30% more than partner rate at firm B. And associate rate, $650. That's like 10, 15% more than firm B. So obviously that's a really expensive firm. I don't know if we want to spend that kind of money. But in this example, it's an individual legal matter, 195 total hours billed. But the leverage is totally different because the bigger AmLaw firms are more leveraged. And so in firm A, we've got 3.9 associate hours billed for every 1 hour of partner time. In firm B, even though it's quote unquote cheaper, there's only 1.5 hours of associate time for every 1 hour of partner time billed. And the ultimate result is actually firm A was a little bit more expensive in her example, but only by about 5%. And was it worth it? Was it worth, not deepening a relationship that you have with a panel firm, with a big firm, in order to save 5% on this legal matter? And maybe there's a quality differential. I don't know. But the point is, to me, it's like squeezing a water balloon. If you squeeze just the rate end of the water balloon, then the water is just going to go to the other end of the balloon. You're not actually making a difference, and you have to take a holistic approach. But that's hard because of some of the issues that we're going to be talking about today. So the 3 takeaways that I want to go into, the first is that there's different staffing patterns at different firms, and we'll give you hard data on that. I think everybody knows that, but we're going to give you exact numbers. The second thing is differentials in staffing patterns in corporate law departments. Now, some of that is tied to the type of firms that they use, but there may be some other things that are going on that affect that utilization. And the third thing is really not a presentation anymore, I hope, but it's a discussion that I hope to have with you folks about what you have personally observed and experienced with staffing ratios and what you're doing to try to manage staffing ratios, if anything. And if you're not doing anything, that would be great to hear too. I suspect that a lot of people don't really know how to deal with these issues, which is totally forgivable because of the ambiguity that we're about to go into. But as you get more and more mature and you sort of figure out the basic building blocks of legal operations and you get those things to where it's like it becomes routine. You can do it in your sleep. You're going to be forced to struggle with some of these issues, I believe. Like I said, my name is Nathan Semenska. I am the Director of Legal Operations and Industry Insights for Wolters Kluwer, which means that my job is to educate myself, clients, potential clients, and the industry at large about legal operations trends and best practices. I'm a licensed attorney. I have an MBA. I've worked in a law practice. I have worked in spend management for Elevate Services. I worked for Stephanie Corey, the co-founder of Clock, in her legal technology consulting practice. And I now work for Wolters Kluwer. I've been doing this for approximately 4 years. So let's talk a little bit about the differences that we see across different law firms in terms of staffing. We do see important differences. Here is a 100% bar chart of the differences that we see. I broke these out by AmLaw rank, and you can see this is associate, partner, and other, the blue associate, orange partner, gray other, and this is over a 6-year period. So it doesn't have to do with what's going on in any particular year. It's smoothed out over 6 years. So this should be pretty representative of what's going on in general. And what we see, I think everybody knows, but they don't know the exact numbers, is that the bigger firms are a lot more leveraged. We see approximately 50% of all hours being in AmLaw 10 and AmLaw 20 firms, and to some extent AmLaw 50 firms, being billed by associates. So associates are the workhorses at those huge firms, and we see lower partner utilization. Is that good or bad? I don't know. Maybe, does it depend? Yeah, probably. Does it depend on the type of matter? Does it depend on the type of fee arrangement? Yeah, all that stuff matters. Context matters. So it's really hard to say that it's good or bad. You look at the other end, and you kind of see the opposite situation where AmLaw 151 to 200 firms, only about 30% of their hours are billed by associates, and 49% are billed by partners. So you could look at that and you could be like, wow, what a waste. I mean, why would you not have associates do more of this work? Certainly, this must mean that partners are doing work that could have been done by associates and they're doing it themselves. What a waste of money. I don't want to pay partner rates for that. You could say that, maybe you're right some of the time, but there's a lot of ambiguity, and you could make similar arguments with the top firms. You could say stuff like, oh, they've got so many associates, they have to keep them busy all the time. If there's an associate sitting around not billing, then they're paying that person basically a minimum of $200,000 a year, and they're making $0 in revenue off of them. So they're just like throwing them into random legal matters to keep them busy, because they simply can't afford them to sit idle even for a couple hours. It's too costly. Who's right? I don't know. Both of those are legitimate concerns, in my opinion. I do think that there is a basic good faith in the legal industry. I don't think that you need to be paranoid and assume that all of these staffing ratios are jimmied all the time to create an advantage for the firm that comes at your expense. But at the same time, when the cat's away, the mouse will play. And if you're not paying attention to these issues, then you're leaving the door wide open to stuff that may be conscious or may just be an accident, like really sloppy staffing ratios that don't make sense. So we're going to talk a little bit more about the differences that we see. Here we see, just to go, to make the difference more stark, we see overlapping histograms of how the AmLaw 10 compare to the AmLaw 151 through 200 firms. So to explain this a little bit, the y-axis is the percentage of law firms that are exhibiting the staffing ratio that is explained in the x-axis. And the x-axis is the different buckets. And this is just about associates in this visualization. So we see in the AmLaw 1 through 10 firms some variation, but a fairly narrow spread of ratios. The most common situation being that associates bill somewhere between 50 and 70% of all the time that's coming out of those firms. And you do see some slight outliers where 10% of these firms have between 70 to 80% of firm time billed by associates, and then some lower ratios in about 10% of these firms. Keep in mind, there's only 10% of these firms, but generally speaking, we're talking between 50 and 70% in an Am Law 10 firm of time is going to be billed by associates. If we look at the Am Law 151 through 200 firms, we see a couple things. We see that associate utilization is a lot lower. The typical modal situation, the most commonly occurring situation, is that between 30 and 40% of associate of time is associate time. But we also see a greater variety. We see a greater diversity, and I think this is because the smaller firms get, the more quirky or odd they can be. They're not, there's more diversity. They're in different parts of the country. They have different market dynamics. They've evolved for different reasons. So you're going to see some Am Law, 151 to 200 firms that have ratios that look similar to Am Law 10 firms. But then you're going to see other ones that have extremely low utilization, like 23% of these firms have less than 20% of time billed by associates. Is that good or bad? I don't know. That's something that you need to look at on a case-by-case basis and decide, in my opinion. Here's some more information that this time about partners, and obviously it's somewhat of a reverse of what we just looked at. But if you look at the blue, that's the Am Law 1 through 10 firms, and we see that 50% of them have between 30 and 40% of all time billed by partners. And then with the Am Law 151 through 200 firms, you see the same diversity and variety that we saw with the associates, where as a small number, but 2% of those firms are having between 30 and 40% of time billed by partners. So that's comparable to the big firms, but it's fairly rare. And then at the other end, you see 17% of these firms have over 80% of time billed by partners. And then you get back into these questions. It's like, can this really be right? Under what imaginable scenario would you want 80% of all hours to be billed by partners? This is a little bit sort of beside the point, but I'll bring it up because it's a question that came up in a discussion with a client of ours the other day. Partners aren't partners anymore. Something like 29% of people working at law firms are partners, but a third of those are not equity partners. So are they really partners, or are they just glorified associates that they retitled in order to make them feel included as a retention tool? And are they billing equity partners out at different rates than non-equity partners? Because to me, it's like, if you don't think that this person is the type of person that you want to give equity in your firm, then why should I have, you don't have that level of buy-in with them. Why should I? They're not a real partner. Is it fair to ask me to pay the same rate for a quasi partner because a partnership isn't what it was 20 or 30 years ago? Let's talk a little bit about what the data shows about paralegals. I find this to be somewhat interesting. I think that there's a lot of sociological issues going on in the legal profession. I think that everyone's aware that there's issues with the lack of diversity in the legal profession. There's probably also some sort of latent classism, I would say, in the legal profession. And you hear this not described as classism exactly, but you hear a lot of talk about ALSPs and why aren't people using ALSPs more, and this sort of poo-pooing of ALSPs, saying that they're less than and it's not going to be as good and this and that and all these different reasons why you should minimize your use of ALSPs. Obviously, those are arguments that are coming from certain quarters and not others. I personally think that ALSPs are a great deal. I think you can save a lot of money. I think having an AmLaw 10 or AmLaw 20 associate do document review work for $600 an hour is bonkers. And why not have an ALSP do that? I think more and more people are coming to the same conclusion that I just expressed. But I still think the ALSPs are underutilized, and they tend to be utilized not in a holistic sense where you're sending all of your document review and other sort of process work to ALSPs, but on an individual legal matter where you put out an RFP and then maybe the ALSP gets some of it, but maybe sometimes they don't. But what about paralegals? You actually don't hear that much about paralegals. I don't know why. I don't know why it hasn't been brought up. But why do we even need to have this discussion about ALSPs if there's paralegals that work at the firms, and presumably their quality, which is why the firms continue to have them on the payroll. And so what I've pulled out here is a distribution of the kinds of staffing ratios that you see about paralegal utilization in AmLaw firms. This just isn't any firm. It's only the top 200 firms in America over a 6-year period. And we see a huge variation. On the far left, we see that 12.8% of law firms have fewer than 1% of all hours billed by paralegals. And then at the far right, we see kind of the other situation where 3.9% of law firms have almost 20% of all hours billed by paralegals. And I've looked at this data on a more granular basis than what you're seeing right now. There's some huge firms that are billing paralegals out the wazoo. So it's not just these quirky little, AmLaw, whatever, 198 firms that bill a lot of paralegal time. There's all sorts of firms that are billing a lot of paralegal time. But then that raises questions like, okay, well, if AmLaw number 7 bills 12% of all time through paralegals, then why is AmLaw 8 billing less than 1%? I don't take these numbers. I'm not saying numbers about specific firms. This is just a hypothetical. But if one firm can do work and presumably their portfolios are somewhat similar and 20% of that can be sent to paralegals, why can't 20% be sent to paralegals at a different firm? Hello?
You want to say something? I make that.
Sorry.
Bronco or KJ, can you help us mute some of the people who might be creating some noise for Nathan?
This is KJ. I just took care of that one.
Thanks so much.
All right, thanks a lot. So I think you get the point. I'm not saying that a particular, level of paralegal utilization is good or bad. I'm just raising the question. It's something that needs looked at, in my opinion. And probably if you're using a firm that has less than 1% of time billed by paralegals, then there's probably some paralegal work that's being done by associates because there's not anyone else to do that work. And there's always going to be some work that could be done by a paralegal. So enough about paralegals. Let's talk a little bit about a variation in staffing ratios over a period of time. So let me explain this because it's a little bit confusing. I'll give you a hypothetical example. If you are using firm X and in 2019, firm X has 50% of all hours billed by associates, and then in 2020, it's 60%, then that's a 10% difference between 50 and 60%. So that's the variance, the year over year variance within an individual firm. And So what we've done here is we've looked at the variance between the minimum and the maximum associate utilization within each individual law firm over a 6-year period. And then we broke that out into 4 different groups. So the firms in the left-hand group are ones that show very little variance in their level of utilization of associates over the 6-year period that we looked at. And the people over on the right, we see a fairly significant level of variance in their associate utilization. And again, I think this doesn't really tell you anything except that this issue is worthy of more study. But there's certainly arguments that can be made that you want there to be some variance in the ratios that you're seeing year over year, because market conditions are changing. The type of demand for different types of work is changing all the time. And if the staffing is exactly the same every year, despite changing market conditions, then you might argue that that reflects not the best staffing to solve the client's problems in an affordable way, but the law firm concerned that they need to keep people busy. Again, they're paying these people hundreds of thousands of dollars a year. If they only bill 1,000 hours in a year, they probably lost money on that timekeeper. So time is money in the legal profession. So if we see over on the left, fewer than 10% of law firms, 12.3% of law firms have less than a 10% variance in associate utilization over a 6-year period. So it's quite consistent. And that could be because that's the best way to get the job done. But I think the reality is that law firms may be substituting their own needs from business perspective over those of the client. And then if you see on the right hand side, some fairly significant variances, about 16.1% of law firms see between a 30 and 40% difference in the utilization of associates between the high and the low over a 6-year period. Now, I will say, just to keep myself honest, the stuff on the right may not be as credible as the stuff on the left. And that's because we are one e-billing company. We're not the only e-billing company. And there's 2 or 3 other serious competitors that we have. So it may be that these law firms don't have the level of variance that we're seeing on the right, that they have that variance within the data that we looked at. But if we got all of the e-billing data in the world, that variance might be smoothed out. And I can't answer that question because I don't have that data, but I did want to point that out to you because I do not want to mislead you. I'm just giving you the best analysis that I can based on the most complete benchmarking database in the world. So enough about what's going on at law firms. I now want to talk a little bit about what is going on with staffing in corporate law departments. And as with law firms, we see fairly significant differences in the staffing ratios that we see across different law departments. This is the same 6-year period that we looked at with the law firms. On the y-axis is the percentage of corporate law departments with a given level of timekeeper utilization in partner versus associate. And then on the x-axis, we see various buckets representing how much those particular timekeepers are being used. So if we look at the far right, we see that 6% of corporate law departments have 50% or more of all hours being billed by partners. This, by the way, is not just AmLaw. This is all firms. Okay, so it's a holistic picture. But 6% of corporate law departments are having over 50% of hours billed by partners. If you look at the far left, you'll see a different situation where 6% of corporate law departments have less than 5% of all hours billed by partners. And to me, again, you never really know, is this good or bad unless you're there in the trenches. But on its face, it sounds kind of weird that, partners are not really that involved in the legal work. It seems like you would want more partner involvement to make sure that associates aren't, spinning their wheels, and that they're getting trained properly so that they can become partners. You also see in the far left the associate numbers. About 4% of corporate law departments are using, having a less than 5% of all billings, of all hours represented or billed by associates. So again, on its face, it doesn't sound right. Like how could you only have 4 out of every 100 hours billed by associates? Who's doing all of this work then? Aren't associates supposed to be the workhorses? And aren't you probably paying for partners that do associate work if you have that staffing ratio? But neither of those are typical situations. The typical situations are the taller bars that you see more towards the middle. So for associates, the most common situation is between 25 and 30% of all time is billed by associates, but it's almost as equally common that between 35 and 40% of work is done by them. That's the two tall orange bars there. And then for partners, we actually see that the most common situation is between 45 and 50% of time is billed by partners. But if you go to the left, you'll see a number of other pretty common situations where there's a lot less partner involvement. So what's good, what's bad? I don't know. Pick your poison. It depends on the context. I think you really have to be in the trenches to know the answer to these questions. But by looking at some of this benchmarking data, perhaps you can decipher not just what you're doing currently, but maybe you want to do things a little bit differently based on some of the information that we're seeing. I don't want to go into this slide too much. It's busy. This is actually something that I'm giving you so that you can take home and look at it if you need, if you're having trouble going to sleep, perhaps. But what we've done is we've broken out staffing ratios. On the left, you see associate, in the middle, paralegal, and on the right, partner. And we've broken it out by matter type. And this is all litigation, because litigation is about 60% of legal spend. If you go and download the report in a week or two, there'll be a separate chart for non-litigation. But this is information that you could compare against the work that you're having done and do sort of a sanity check to see if you're out in left field or if you're more or less similar to what other people are experiencing. I think it's tricky because in general, I would argue that it's good to be normal. On average, it's good to be average. Certainly, if average is mediocre and you want to be excellent, then maybe you won't fall into one standard deviation of average. But on average, even though being with the herd, sticking with the herd sounds kind of like not being a leader in certain ways, it's also potentially the sweet spot where if you're doing everything that other people are doing, there's safety in numbers, and you can have at least some comfort in the fact that you're not crazy. But if you look at these, you do see some things that you wonder about. If you look on the far right, you see the partner numbers, and I'll just use this one example and then we'll move on. But bankruptcy and collections. So 55% of all bankruptcy and collections hours are billed by partners. About 9% is billed by paralegals, and the rest is done by associates. Is that the number that it ought to be? It would be interesting to compare this because I used to do bankruptcy when I was an attorney, And I know that bankruptcy has dropped off a cliff since 2008. It basically went down every year. And I think it's probably at about 50% of what it was in like 2010, something like that. And I know that there's not a huge demand for associates in bankruptcy because of that. And the fact that 55% of that work is being done by partners may be a reflection of the fact that partners are the ones that need to be doing that type of work because that's the level of sophistication that it requires. But it may also be that bankruptcy and collections associates got the memo and they're like, well, gee, this isn't that great of a specialty to be in. There's not that much demand. I'm going to go ahead and move my specialty over to something else where I will have more job security. I don't know the answer, but if you take these numbers and compare them to what you're experiencing in your corporate law department and you see a big difference, you may want to investigate that further. So that is kind of the presentation. I was hoping that we could have a little discussion because I'm not a person that's in the trenches anymore. I talk with people who are all the time, and I hear all sorts of interesting bits of information from those people. But you're really the real experts here. I'm just kind of regurgitating gossip that I've heard and combining that together with benchmarking data. But I'll tell you, most of the people that I'm talking to are managing staffing ratios in a very passive manner at best. I would say that the most sort of aggressive hands-on approach that I've heard about is a client of ours, a huge financial institution that put their top 15 matters with work plans, that had defined staffing ratios. And then they baked that in to the invoice review process, which we perform for them. And every month they're looking for any kind of significant deviation from the staffing ratio that was agreed to. And if it's within a reasonable range, then nothing is said or done about that. But if they see a significant change from what was expected, then they start to worry that something is happening on this case, that something is changing, and that there's probably a change of scope associated with that and a new plan. Either that or the firm has sort of got distracted and isn't adhering to the original agreement about staffing ratios. But that's pretty much the most advanced approach that I've heard. I hear other people not worrying about it, basically decentralizing it to in-house counsel and just kind of hoping the in-house counsel cares about these issues and has a good idea of what the staffing ratios ought to look like. I think in many cases, frankly, in-house counsel might not know. They know how it was at their firm that they used to work at, but the type of firm that they're looking at currently may have nothing in common with the sort of firm that they came from. And there's a lot of ambiguity here. So I'd be interested to hear from you folks about, what you've experienced, things that you've tried, what has worked in your opinion, what hasn't worked. Any takers?
Nathan, first, just gratitude for sharing these true insights. Some of the data I've seen today really blew my mind, and I'm frankly embarrassed that some of it feels new to me when it shouldn't. But I'll go back to the point that you just made just now about what maturity looks like, what we could aspire to do different or better. Can I ask you a quick question, or the group, right, our colleagues on the call? Let's take that example that you just spoke about where the firm with perhaps more maturity in this area actually came to the table or published this expectation of what the staffing was to be on matter X. They don't come up with that in a vacuum, right? That is in conversation with the relationship or other partners at the beginning of a matter, or perhaps if they're a panel or a preferred network firm, it is just expected that this is the way we're going to work together. We're going to engage. It's understood in terms of how we're going to work. But I'm so far back from that I can't even envision how that recipe that staffing ratio mix comes to be. Do you have a perspective on that? Or perhaps our colleagues could come off mute and say, yeah, I do this well, and here's how we actually come to get to the answer.
I've got some ideas, but let's see if there's somebody else first. If nobody, I mean, I think in-house counsel talks with the firm, and they submit a draft. Probably the firm is asked to submit more or less an Excel spreadsheet showing the staffing ratios that they expect to have, ideally broken out into different phases, because it probably should differ based on different phases. And maybe this is getting too detailed and cumbersome, but you know, I don't think it's uncommon for that to be broken out by individual timekeeper names, right? But then, so I think that actually happens sometimes, like a non-trivial number of times. I think the best laid plans often don't get followed through on, right? So it's one thing. And then life happens, right? So you've got your beautiful Excel spreadsheet with this terrific staffing ratio that you really meditated on, and it's really a work of genius. And then you get hit with you know, some $1 billion piece of litigation, and all of that's forgotten. And then like 2 years later, you go back and nothing happened the way that your terrific Excel spreadsheet said it was going to, but you're satisfied with the work that you're getting. And because these issues are so ambiguous, it's not like you can complain and say, oh, well, obviously this is not a good bargain the way that you put the staffing, and you know, this is probably affecting quality because of X, Y, and Z. Those statements are so theoretical and hard to prove, even to the people closest to the work. I think even these, you know, even partners, like, I mean, that this isn't a science, right? So I think it's a tricky issue.
Yep, I would agree, Nate. I'm just speaking from personal experience, you know, big ticket litigation, you know, like patent litigation, especially for us as a medical device company. You know, we've gone towards a lot of flat fixed fee phase-based billing to avoid some of those staffing ratio, I don't say arguments, but negotiations, or, you know, because, you know, if you want to have, you know, 10 associates on the same call. We ran into that issue, I know, historically, where, you know, you get in a conference call, you schedule it with the lead, you know, your lead in-house counsel and external counsel, and then they start adding in people to the call, and then next thing you know, you're paying for 6 people to attend the same conference call. So we kind of got into that, and the flat fixed fee eliminated a portion of that. But then we get into, you know, how are we evaluating and measuring that value of a flat fixed fee versus an hourly, right? So, you know, it's kind of like that balancing act. But I think you've already mentioned this once. It can be based upon the subject matter, right? If it's a high risk, you know, high exposure matter, or if it's just your cookie cutter regular, you know, employment matter, you're not treating those the same, right? So.
One would hope, yeah. It's interesting that you bring up AFAs, because that came up with a client of mine that I was talking to yesterday. He kind of said the same thing that you said. It's like, we're sick and tired of, you know, doing all these best laid plans for staffing ratios that then disappear into the ether as if they had never happened. They're hard to enforce. I mean, who's got time to track all this stuff? And then right. And then, like, you know, persuade people to change their behavior if they've deviated from what's agreed to, especially when it's not clear that what is agreed to is any better or worse than what actually happened, right? But the other thing that's cool about the AFAs that my friend yesterday said is I presume that many of the people on this call have billing guidelines that say we're not going to pay for summers and we're not going to pay for first years, okay? Which is fine, I get it, because they're wet behind the ears, and even though I'm sure they're smarter than me in most cases, they are not particularly experienced. So who wants to pay, you know, $500 an hour for a 23-year-old child, right? Not not me. but the firm has to do something, right, with this person. It's not really fair, to say, well, look, I'm not going to do business with your firm unless you're hiring kids from T14 law schools. And then those kids won't work for you unless you pay them $200,000 a year. Now that's how much it is, right? And then the client's like, even though I won't pay for anybody besides those tier 14 kids, don't send me an invoice for them. I just want you to pay them, $220,000 a year, not counting bonus, but never let me see that on an invoice, right?
Right.
But
Well,
if
they're gaining the experience, right? So,
sure,
that's the point. And then, learning about your business, learning about, your company's business.
But
so later down the line.
the flat fee AFA is a place where they can go and do substantial work and
Right.
get experience and not have to worry about the money aspect. They
Right.
are helping to generate, revenue for their firm. So it's a better deal from that standpoint for the firm. And yet you're not having to pay outrageous rates for someone who grew up with a cell phone.
Hey, Tara, this is Mike Stein. First, you can take care of the 6 billers for a call in your billing guidelines, so you don't need to deal with that if you put something like that. But Nate, I do appreciate your comment about LBA and looking at the blended billing. And I think that that's a great option that I want to pursue as well.
Thanks, Mike. I assume that's Mike from QVC, right?
Yes,
it the same
is.
one?
It
Okay.
is,
How's
Nate.
it going?
Yes. And
How's it going?
Thanks for your reply yesterday.
Yeah, no worries. Thanks. I think that invoice review is going to continue to become more and more powerful. I think a lot of you are probably aware of Sally. It's a Toby Brown effort. Jim Hannigan is involved with it from Koblenz. It's going to be a long road, but in my opinion, Sally is going to be put together with invoice review and other things that are going on with e-billing. And eventually, I'm not talking anytime soon, but 10, 20 years from now, we're going to have like a true should cost analysis for pretty much any type of legal matter that you could think of. Right now, we have to benchmark against our own past experience. And of course, the more exotic the legal matter becomes, the less experience any particular client's got with that. If they have access to a benchmarking database like we have, then there's going to be more, right? But there's still this fundamental issue that the legal industry struggles with to create apples to apples benchmarking of total outside counsel costs on various types of legal matters. I think in the meantime, until we crack that nut, invoice review is a great inlet to monitoring staffing ratios and having someone other than in-house counsel do that, because I'm not disparaging in-house counsel. Frankly, they have a bigger fish to fry a lot of times, right? But if you have a person whose only job is to review invoices and they don't do it, they're not going to last very long. Therefore, they're going to do it. Just my observation. Reese, are you going to chime in with something?
I have a question, Nate. First of all, like Kelly, I really appreciate, as I've told you before, when we've talked about some of your data analytics, everything you're doing, because it does give us insight into a much broader world than what we have. Can you do me a favor and bring up your deck again and go to slide 10? I'm just curious about something, and if you've looked at this at all.
Let's see here. Why am I struggling? Okay, here we go. Slide 10.
Here's what I always wonder. Like, do you have any insight into average billed hourly rates in 1 to 10 on the far left the 50% that are associates, and the 49% average hourly rates, that is the partner time in the 150 to 200. Like, are we paying the same rate for an associate in the top tier firms as we are for the partners in the 49%?
You're making me talk about stuff that I wanted to talk about anyway. So the real rate report comes out every year. It came out, I think, in the last month or so from my company, and it breaks all this stuff out. Now, unfortunately, perhaps it breaks stuff out by the number of attorneys working at firms, not by AmLaw tier. So it doesn't balance out exactly with what you're seeing here. But I did notice that firms with between 200 and 500 attorneys, partners at those firms now actually bill less than associates at firms with over 1,000 attorneys. Obviously, there's not a ton of firms with 1,000 attorneys, and I know that those tend to be like really smart people from great law schools and stuff. But still, it just makes me cringe a little bit when I think of like a 60-year-old partner that's done 150 jury trials billing less than a 25-year-old kid.
Yeah, I think in the last couple of years, it's become more imbalanced, and it's only going to become more imbalanced because I don't know what other people on this call are seeing, but if all firms, we still have the 150 to 200 on your far right here with our average partner hourly rates below $1,000 an hour, and the 1 to 10 associate rates are going up to 1,000 and above.
Yep.
Well, if you've got somebody who's making $1,500 an hour and they raise rates 10% per year, in 3 years, we're going to be $2,000 an hour for that person, which is untenable.
Yep.
And the $500 an hour person is only $750 an hour in 3 years. Like, it's just becoming so skewed. Like, we've got to, I think the only solution to this, as I negotiate rates with, and I'm sure many of my peers are, the big firms that are getting all this work are able to push back because they've got so much volume. And therefore they just keep raising the rates because people keep paying it. Right. We have to move to lower cost firms. And okay, fine, the 150 to 200 on the right, 50% of the work is by a partner, but exactly to your point, if it's cheaper than the 50% that are associates on the left, and you're probably getting better, you maybe are getting a better work product, we should be using that smaller firm, even if only 30% of the work is going to an associate.
That's how I feel. However, I don't think that's what's going to happen, right?
I know, but that's where we need to go. Yeah.
I think it's like not to be a pessimist on this issue, but I think that this is you can win as an individual corporate law department. There's bargains out there. When you start talking the kind of money that you just brought up, there's bargains where you can do way better on a lot of this work, if that's what you're looking for, right? And I'm not talking about compromising quality.
I agree.
But that is not where I see the average corporate law department heading, which is actually good. If you are a bargain shopper and everyone else is shopping at Tiffany's and you're at Target, then you've got some negotiating power because you're the only person standing in the line at Target.
Yeah.
Anybody else?
Well, I think we could go on forever, and yet I see we are at time. Reese, thanks for coming off mute. You as well, Mike, for contributing and asking Nate for extra topics where he wanted to go anyway. Nate, we would just conclude with more gratitude. I am continually impressed by the benchmarking and other type of data that your crew puts out, and your thought leadership in particular. And thank you for bringing that to bear within this this great interest group today.
Thank you so much. I'm flattered. Thank you all. I really appreciate, your feedback and your intelligent comments. I continue to believe that the intelligence resides in the trenches.
We'll
Thank
meet you
Nate.
there, Nate. We'll meet you there when you're ready to come back. Thank you, everyone. Have a great
Excellent.
afternoon.
I know. Thank you all.
Have a good
Happy
one.
St.
Bye-bye.
Patty's Day. Bye.
Thank you.